Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only. We are not financial advisors, legal professionals, or licensed mental health practitioners. Laws regarding 401k distributions, divorce settlements, and community property vary significantly by state and jurisdiction. Furthermore, the discussion regarding the history of mental health in the United States is based on historical records and academic research, not clinical diagnosis. You should conduct your own due diligence and consult with qualified professionals, including certified divorce financial analysts, family law attorneys, and licensed therapists, before making any financial, legal, or health-related decisions. There is a silent killer of the American retirement dream that has nothing to do with market crashes, hyperinflation, or bad stock picks. It is a legal instrument known as a QDRO, a Qualified Domestic Relations Order, and for hundreds of thousands of Americans every year, it is the moment they realize their 401k was never actually a personal savings account. It was a shared social contract, one that is currently colliding with a mental health crisis 50 years in the making. We are living through a historical convergence where the shift from collective pensions to individual 401ks has met the total dismantling of the American mental health safety net. This is not just about losing half of your retirement. It is about how the very architecture of our financial system was built on the assumption of a stable nuclear family that the mental health history of this country has actively undermined. If you think your retirement is safe because the numbers look good on your screen, you are missing the largest systemic risk of the 21st century. Today, we are conducting a deep dive masterclass into the intersection of the 401k, the American divorce rate, and the forgotten history of U.S. mental health policy. By the end of this deep dive, you will understand exactly how the legislation of the 1970s created a financial trap for the modern family, why the gray divorce phenomenon is the single greatest threat to your late-stage net worth, and how the historical movement of deinstitutionalization in the U.S. directly correlates to the financial instability of the modern household. We are going to unpack the case studies of the ERISA Act, the psychological toll of the sunk cost fallacy in long-term marriages, and provide you with the historical context necessary to navigate the most expensive legal process a human being can undergo. This is the truth about what happens when your mental health and your compound interest collide. To understand why a 401k divorce is so uniquely devastating in the 2020s, we have to travel back to 1974. This was the year of the Employee Retirement Income Security Act, or ERISA. Before ERISA, the American worker relied on the defined benefit pension. In that system, the risk was on the employer. If a couple divorced, the pension was a future promise of a monthly check, often harder to split and less visible in the immediate present. But ERISA paved the way for what we now know as the 401k, which was codified just a few years later in 1978. This shifted the entire burden of retirement onto the individual. Suddenly, wealth was not a promise from a company. It was a visible liquidish balance in a private account. At the exact same time this financial shift was happening, the United States was undergoing a massive, under-discussed transformation in mental health care. From the late 1960s through the 1980s, the U.S. moved through a period known as deinstitutionalization. The goal was noble on the surface: move patients out of state-run asylums and into community-based care. However, the funding for that community care never fully materialized. This created a new reality for the American family. The home became the primary facility for managing chronic stress, trauma, and mental health struggles that were previously managed by the state. Consider the historical trend of the early 1980s. You have the birth of the 401k, which requires decades of disciplined, consistent contributions to work. Simultaneously, you have a mental health landscape where families are under more psychological pressure than ever before, without the institutional support systems of the past. When we look at case studies from this era, we see the divorce rate begin to climb, peaking as these new financial vehicles were being introduced. The 401k was designed for a 40-year career and a 50-year marriage. It was not designed for the volatility of the modern human psyche or the reality of a no-fault divorce world. In a divorce, the 401k is often the largest liquid asset next to the family home. However, unlike a home, it cannot be easily divided by a simple sale. This is where the QDRO comes in. A Qualified Domestic Relations Order is the legal mechanism that allows a 401k to be split without the immediate 10% early withdrawal penalty or the standard income tax hit, provided it is done perfectly. But the psychological cost is where the mental health history of the U.S. becomes relevant. When a spouse sees 50% of their lifetime labor transferred to an ex-partner, it triggers a specific type of financial trauma. This isn't just about money, it's about the time value of a human life. Historical data shows that for many Americans, the 401k represents their security blanket in a country that lacks the social safety nets found in other developed nations. In the US, your 401k is often your health insurance fund for old age, your long-term care fund, and your legacy. When that is halved, the mental health implications are profound. We see a spike in situational depression and financial anxiety disorder, specifically tied to the loss of retirement stability. The history of U.S. mental health is a history of shifting the burden of care to the individual, and the 401k is the ultimate expression of that individual burden. Let's look at a case study of the gray divorce. Divorce among those aged 50 and older. Since 1990, the divorce rate for this demographic has doubled. These are the 401k pioneers, the first generation to move entirely away from pensions. When a couple divorces at 55, they have no time for the power of compound interest to repair the damage. If a $1 million 401k is split into two $500,000 accounts, both parties are suddenly below the threshold for a comfortable retirement in most U.S. states. The historical trend shows that this demographic then experiences a higher rate of late-onset isolation, which further exacerbates mental health issues. The link here is clear. Our financial structures assume a level of psychological and marital stability that our history does not support. The Great Deinstitutionalization meant that if a spouse struggled with mental health, the financial impact was internalized within the marriage. If that struggle led to divorce, the 401k became the settlement fund for years of unpaid emotional labor or suffering. In legal circles, this is often discussed as equitable distribution, but in the context of mental health history, it is the final bill for a society that stopped providing collective care. Furthermore, we must examine the intergenerational trauma of the 401k split. When parents divorce and their retirement is gutted, the burden of their care in old age often falls on their children. This is the sandwich generation effect, where middle-aged adults are caught between supporting their children and their financially depleted parents. This creates a cycle of chronic stress that traces its roots directly back to the policy shifts of the 1970s. We traded the stability of the collective for the potential outcomes of the individual market, and we did so without a backup plan for when the human element, the marriage, failed. Every step of a 401k divorce is a minefield of potential outcomes. If the QDRO is misfiled, the tax implications can be catastrophic. If the valuation of the 401k is done at the wrong cutoff date, one spouse may lose out on thousands of dollars in market gains, or be stuck with thousands in market losses. This financial complexity, layered on top of the emotional devastation of a dissolving marriage, creates a perfect storm for mental health crises. The U.S. system, by design, requires a high level of executive function to manage a 401k. However, the first thing to fail during a mental health crisis or a high-conflict divorce is executive function. This is the deep-seated irony of our modern era. The moments when we most need our financial resources to be stable and easy to manage are the exact moments when the legal and financial systems become most complex and volatile. We are going to explore the specific ways you can mitigate these risks, but first, we must acknowledge the gravity of the situation. You are not just managing an account. You are managing a historical legacy of economic and psychological shifts that have placed the entire weight of your future on your ability to stay married or, failing that, your ability to navigate a system designed for institutional efficiency, not human recovery. To see how this plays out in the real world of 2026, let us look at a case study involving a character named Michael. Michael is 54 years old and lives in a high-cost-of-living suburb of Atlanta. He has spent the last 28 years working as a mid-level operations director for a logistics firm. His 401k balance sits at $950,000. For Michael, this number represents more than just a digit on a screen. It represents every late night, every missed weekend with his children, and the security he believes will allow him to finally exhale at age 65. However, Michael is currently entering the second year of a high-conflict divorce. Imagine if Michael assumes that because he was the sole earner for the first decade of his marriage, his 401k is his personal property. He is operating under a psychological framework of individual meritocracy, but the legal reality of 2026 is grounded in the Retirement Equity Act of 1984. This landmark legislation was a turning point in U.S. financial history. Before 1984, It was entirely possible for a worker to sign away their spouse's rights to survivor benefits without that spouse ever knowing. The 1984 Act changed the social contract of the American household by mandating that a spouse has a legal claim to retirement assets earned during the marriage. This shift was designed to protect non-earning spouses, often women, from being left destitute. The historical trend since 1984 has been a move toward treating retirement accounts as marital property, regardless of whose name is on the account or who made the actual contributions. In Michael's case, his logistics firm's plan administrator receives a draft of a qualified domestic relations order. Michael's mental health begins to deteriorate as he realizes that his $950,000 is about to be cleaved in two. This is not just a financial transaction. It is a neurological event. The human brain processes financial loss in the same regions where it processes physical pain and mortal threats. Historical trends in psychiatric research show that the loss of perceived future security can trigger a state of chronic hypervigilance. In Michael's story, the process of the QDRO reveals the deep inefficiencies of the system. First, Michael and his spouse, Sarah, must agree on the valuation date. This is a critical step that many people overlook. Imagine if the market is volatile, as it has been throughout the mid-2020s. If the valuation date is set for January 1st when the market is at a peak, but the actual transfer of funds does not happen until June after a significant market correction, Michael could be forced to pay Sarah a dollar amount based on a balance that no longer exists in his account. This potential outcome could leave him with significantly less than 50% of the actual remaining assets. The step-by-step reality of a 401k split is an administrative gauntlet. Step 1 is the discovery phase, where every statement from the date of marriage to the date of separation must be produced. This often requires digging through digital archives and defunct portals, a task that is incredibly taxing for someone already suffering from the cognitive load of a divorce. Step 2 is the drafting of the QDRO itself. This is not a standard form you download from the internet. It is a highly specific legal document that must meet the requirements of both the Internal Revenue Code and the specific rules of the employer's retirement plan. Step 3 is the approval by the plan administrator. If a single word is out of place, the administrator will reject the order, sending the parties back to the beginning of the legal process, all while attorney fees continue to accrue. This brings us to a critical intersection with U.S. mental health history: the rise of the standard of living anxiety in the 1990s and 2000s. As the U.S. shifted away from community-based mental health support, the burden of maintaining psychological well-being fell on the individual's ability to maintain their socioeconomic status. When Michael sees his retirement projections cut in half, he isn't just worried about money. He is experiencing a collapse of his identity. Historical data from the early 2000s suggests that financial stressors are a leading indicator of clinical depression in men over 50. In 2026, with the added pressure of digital transparency and the constant comparison of social media, this effect is magnified. The case study of Michael and Sarah highlights another hidden complexity: the tax trap. Under Section 72T of the Internal Revenue Code, there is generally a 10% penalty for withdrawing 401k funds before age 59 and a half. However, there is a specific historical provision related to QDROs. If Sarah receives her portion of the 401k via QDRO, she has a one-time opportunity to take a cash distribution without the 10% penalty, though she will still owe ordinary income tax. If she is not properly coached by a professional, she might miss this window and roll the funds into an IRA. Once those funds are in an IRA, that one-time penalty-free access disappears. This is a classic example of how the lack of integrated financial and legal education in the U.S. creates a system where only the most well-informed navigate the process without significant loss. We also have to consider the sunk cost fallacy through a historical lens. Throughout the mid-20th century, the social stigma of divorce acted as a barrier that kept many families together, for better or worse. As that stigma eroded and no-fault divorce became the national standard by the 1980s, the financial calculations changed. People began to weigh their mental health against their net worth. In 2026, we are seeing the long-term results of this. We are seeing a generation that has prioritized individual psychological health, but is now facing the brutal arithmetic of the 401k split. The potential outcomes for these individuals include a phenomenon known as poverty at the finish line, where people who worked high-paying jobs for 30 years find themselves unable to afford basic housing in their mid-70s because their retirement was fragmented in their 50s. Let's look at another scenario. Imagine if a spouse has been using the 401k as a way to hide assets or loan money to themselves through 401k loans. This adds a layer of forensic accounting to the divorce that can take months to resolve. In the U.S., the history of financial domestic abuse is often tied to the control of retirement accounts. Because these accounts are often tied to an employer, the earning spouse can use the complexity of the plan rules to obfuscate the true value of the marital estate. This creates a secondary mental health crisis for the non-earning spouse, a sense of profound betrayal and gaslighting regarding the family's true financial standing. The 401k was never designed to be a divorce settlement vehicle. It was designed to be a steady, compounding bucket of growth. When we force it to act as a liquid asset to be divided during a period of high emotional volatility, we are using a precision instrument as a sledgehammer. Historical trends show that the administrative costs of splitting a 401k, including the QDRO drafter, the actuarial valuations, and the repeated legal filings, can eat up 3 to 5% of the total account value before the split even happens. In Michael's journey through the 2026 legal system, he discovers that his mental health is the most expensive variable in the room. If he becomes too depressed to work or too anxious to make rational decisions, he might agree to a settlement that favors immediate liquidity over long-term growth. This is a trap that many fall into. They want the divorce to be over so badly that they sacrifice the compounding years they can never get back. This is where the history of American individualism backfires. We are told we are responsible for our own happiness and our own retirement, but the system is designed to penalize us the moment those two goals come into conflict. As we move forward, we have to ask, what happens if the 401k isn't just a collection of stocks and bonds? What if it includes complex alternative investments? Or what if the plan itself is a non-qualified plan with entirely different rules? This leads us to the most dangerous part of the QDRO process, the moment the money actually leaves the account. If the transfer is handled as a check in the mail, rather than a trustee-to-trustee transfer, the IRS may view it as a taxable event, triggering a massive tax bill that neither party is prepared to pay. The psychological toll of these technical errors is what we call financial PTSD. It is the lingering fear that the system is rigged and that one's efforts are futile. But there is an even deeper layer to this story. We have discussed how the 401k is split, but we haven't discussed what happens when the 401k isn't there at all, or when it has been depleted by a health crisis before the divorce even begins. We are moving into a territory where the accidental history of the U.S. retirement system meets the intentional history of the U.S. healthcare crisis. In the next part, we are going to look at the valuation date trap in extreme detail. You will see how a 48-hour window in the market can cost a divorcing spouse 6 figures, and we will examine the historical case of a 2008-era divorce that changed how the Supreme Court looks at retirement assets forever. The stakes are getting higher, and the math is about to get much more personal. To understand the sheer magnitude of the legal trap we are discussing, we must look at the landmark 2009 Supreme Court case of Kennedy versus Plan Administrator for DuPont Savings and Investment Plan. This case is the definitive warning for every American worker in 2026. The facts are as haunting as they are instructive. William Kennedy was a long-term employee of DuPont who had accumulated a significant balance in his savings and investment plan, a precursor to the modern 401k structure. When he divorced his wife, Liv, the divorce decree was explicit. Liv signed away her rights to William's retirement benefits. It was a clear bilateral agreement sanctioned by a state court. However, there was one fatal administrative oversight. William never updated the beneficiary designation form held by the DuPont plan administrator. When William passed away, the plan administrator looked at the paperwork on file. Despite the divorce decree, despite the signed waiver of rights, the plan documents still listed Liv as the beneficiary. The plan administrator followed the internal documents and paid out the entire balance, roughly $400,000, to the ex-wife. William's estate and his daughter sued. They took the case all the way to the Supreme Court of the United States. The potential outcomes of this case hung on a single question: does a private contract or a state court decree override the federal guidelines of ERISA? The Supreme Court's answer was a unanimous and resounding no. They established the plan documents rule, which dictates that a plan administrator is duty-bound to follow the plan documents above all else. This means that in 2026, if you do not update your beneficiary forms and file a formal QDRO, your divorce decree is essentially a piece of paper that your 401k administrator has the legal right to ignore. This leads us directly into the heart of the valuation date trap. a mathematical nightmare that ruins more retirements than bad investments ever could. Imagine if Michael, our operations director in Atlanta, reaches a settlement agreement with Sarah on June 15, 2026. At that moment, the market is at an all-time high, and his 401k is valued at $950,000. They agree that Sarah will receive 50% of the account, which they quantify as $475,000. This is step one of the trap. Michael's attorney drafts the QDRO, but because the court system is backed up and the plan administrator is slow to respond, the document isn't officially approved and executed until September 15th. In that 90-day window, a sudden correction in the tech sector wipes 20% off the value of Michael's account. His $950,000 is now $760,000. But because the legal document was written as a fixed dollar amount of $475,000 rather than a percentage of the account, Sarah is still legally entitled to that full amount. Michael is now left with only $285,000. He has not lost 50%. He has lost over 70% of his life savings because of a 3-month administrative delay. This is a common historical trend in U.S. divorce cases where the volatility of the market is not accounted for in the language of the QDRO. The mental health history of the United States tells us that this kind of financial volatility creates a specific type of psychological trauma, known as administrative betrayal. When an individual like Michael spends decades following the rules, contributing to his 401k, and trusting the system, only to have that system cannibalize his savings through a technicality, the result is often a total collapse of social trust. Looking back at the historical trends following the 2008 financial crisis, we saw a massive spike in what sociologists call learned helplessness among the American middle class. People felt that no matter how hard they worked or how carefully they planned, external forces, legal, administrative, or market-driven, could wipe them out in an instant. In 2026, we are seeing the resurgence of this sentiment as the complexity of the 401k divorce process reaches a breaking point. Step by step, the valuation process should be handled with surgical precision. Step 1 is determining the cutoff date, which is the date after which any further contributions or market gains are considered separate property. Step 2 is identifying whether the split will be a fixed dollar amount or a percentage. Historical case studies suggest that percentage-based splits are generally safer in volatile markets, as they share the risk and reward between both parties. Step 3 is the inclusion of language regarding market gains and losses between the cutoff date and the distribution date. If this language is missing, you are essentially gambling with your retirement. Imagine if Michael's lawyer had included a gains and losses clause. If the account dropped by 20%, Sarah's share would have also dropped by 20%, preserving the equitable nature of the split. Without it, Michael is left in a state of chronic stress, refreshing his brokerage app every 10 minutes, watching his future evaporate while he waits for a judge to sign a piece of paper. This level of stress has been linked to increased cortisol production, which over a period of months can lead to significant physical health issues, including hypertension and cardiovascular disease. The history of U.S. healthcare has often ignored this direct link between legal financial trauma and physical decline, but in 2026, the data is becoming impossible to overlook. We must also examine the historical context of the 2008 crash as a precursor to modern divorce psychology. Many of the people divorcing today were young professionals during the Great Recession. They watched their parents' retirements vanish, and they spent the last 18 years obsessively rebuilding. This has created a generation of 401k savers who are hyper-attached to their balances. For them, the 401k is not just money. It is their shield against the repeats of history. When that shield is broken during a divorce, the psychological response is often one of grief, similar to the loss of a family member. The U.S. mental health system is currently struggling to address this specific type of financial grief, which is often dismissed as mere greed or materialism, when in reality, it is a fundamental loss of safety. Another layer of this masterclass involves the investigation of separate property credits. If Michael had $300,000 in his 401k before he married Sarah, that money, along with the growth on that specific $300,000, is theoretically his separate property. But how do you prove that 20 years later? Historical trends in family law show that the burden of proof is on the person claiming the credit. If Michael cannot produce the statements from 20 years ago, statements from a company that might not even exist anymore or from a portal he no longer has access to, the court will likely treat the entire $950,000 as marital property. This is the documentation trap. The history of the digital age is a history of ephemeral data. And in a 401k divorce, if you cannot prove the past, you cannot protect your future. The math of tracing separate property is incredibly dense. It involves looking at every contribution, every employer match, and the specific performance of the funds chosen at the time. It often requires hiring a forensic accountant, whose fees can further deplete the very account you are trying to save. In 2026, the cost of a forensic retirement audit can range from $5,000 to $20,000, depending on the complexity. This is the reality of the American system. You have to spend money to prove that your money is yours. As we look at the historical progression of these laws, we see a shift toward total transparency, but that transparency is a double-edged sword. While it prevents people from hiding assets, it also creates an environment where every single cent is litigated. This leads to a state of permanent conflict that can last for years. The longer the conflict lasts, the more the mental health of both parties suffers, and the more the 401k is drained by professional fees. It is a self-reinforcing cycle of depletion. But what happens when the 401k isn't the only thing being split? What happens when there is a Social Security offset involved, or when one spouse has a secret pension from a previous career? The complexity we have discussed so far is only the surface level. We are about to go deeper into the hidden world of Social Security equalization and why your 401k balance might be used to subsidize your ex-spouse's government benefits without you ever knowing it. In the next part, we will uncover the secret math of the Social Security offset and the devastating impact of the alimony recapture rule, which can turn a simple settlement into an IRS nightmare years after the divorce is finalized. The numbers are about to get even more dangerous. To understand the alimony recapture rule, we have to look at how the IRS views the transition of wealth during a divorce. For Michael, sitting in his Atlanta home in 2026, the urge to move on is overwhelming. He wants to finalize the settlement, even if it means front-loading his payments to Sarah to protect his remaining 401k assets. He proposes paying Sarah $100,000 in the first year, $50,000 in the second, and only $10,000 in the third. To Michael, this looks like a clean break. But to the IRS, this looks like a property settlement masquerading as alimony. This triggers Section 71F of the Internal Revenue Code, the alimony recapture rule. Historical trends in U.S. tax law show that the government is hypervigilant about people trying to circumvent property division taxes by labeling them as alimony. If Michael's payments drop by more than $15,000 during the first 3 post-separation years, the IRS will recapture those payments. This means in the third year, Michael could be hit with a massive tax bill, as the IRS retroactively reclassifies those previous deductions as taxable income. The math is a brutal 3-step process. First, the IRS looks at the drop between year 2 and year 3. Then, it looks at the drop between year 1 and the average of the subsequent years. The potential outcomes of this administrative oversight are devastating. Michael could find himself owing tens of thousands in back taxes at the exact moment he thought he was finally financially stable. This leads us to the hidden math of Social Security equalization. In the United States, Social Security is often the elephant in the room during a 401k divorce. Most people assume that Social Security is a separate government entitlement that cannot be touched by a state court. While it is true that a state judge cannot order the Social Security Administration to split a future check, they can absolutely use the value of those future checks to offset the division of the 401k. This is a critical historical shift in U.S. family law. Imagine if Sarah spent 15 years as a public school teacher in a state where she did not contribute to Social Security because she had a state pension. Michael, meanwhile, has been paying into Social Security his entire career. In 2026, a court might perform a Social Security offset. They will hire an actuary to determine the present value of Michael's future Social Security benefits. If that value is determined to be $300,000, the court may decide that Sarah is entitled to an equivalent amount from Michael's 401k before the rest of the account is even split 50-50. This is the invisible depletion of the 401k. Michael might walk into the courtroom thinking he is splitting $950,000, only to realize that the first $300,000 is already spoken for to balance out a Social Security benefit he hasn't even started collecting yet. The mental health history of the U.S. provides a sobering backdrop to this financial maneuvering. During the 1940s and 50s, the American psyche was anchored by the idea of the family wage, a single income that provided for a lifetime of stability. Mental health during this era was often tied to social conformity. However, as we moved into the 1970s and 80s, and the divorce rate began its historical climb, the American identity shifted toward self-actualization. This shift required a new kind of financial independence. The 401k became the scorecard for that independence. When that scorecard is manipulated by Social Security offsets or tax recaptures, it triggers a profound sense of identity loss. Case studies from the late 1990s show that individuals going through this level of financial complexity often experience what is known as the scarcity loop. Because they feel their future resources are being unfairly drained, they begin to make increasingly risky or short-sighted financial decisions in the present. In 2026, we see this manifesting as people liquidating their 401ks entirely to pay for legal fees, ignoring the long-term impact of losing out on decades of potential market growth. They are trading their 70-year-old self's survival for their 54-year-old self's temporary relief from litigation. Let's look at the step-by-step reality of managing a Social Security offset. Step 1 is the mandatory disclosure of Social Security statements. Many people try to hide these, but in a modern U.S. divorce, these are as discoverable as bank statements. Step 2 is the actuarial valuation. This is not a simple calculation. It involves mortality tables, projected inflation rates, and the COLA cost of living adjustments that the Social Security Administration provides. Step 3 is the negotiation of the offset. This is where the 401k is often used as a bargaining chip. One spouse might say, "I will take less of the 401k now if you waive your claim to my future Social Security survivor benefits." But this is a dangerous game. Historical data suggests that many people underestimate their lifespan, and by waiving survivor benefits, they are effectively betting against their own longevity. The complexity grows when we introduce the windfall elimination provision, or WEP. Historically, this was introduced in 1983 to prevent people from double-dipping into both a public pension and Social Security. If Sarah has that teacher's pension we mentioned, her Social Security benefits might be significantly reduced. If Michael's legal team doesn't understand the WEP, they might overvalue Sarah's future Social Security, leading to an unfair offset that leaves Michael with even less of his 401k. This is why a deep dive masterclass in these topics is essential. The surface level numbers are almost always wrong. The mental health implications of these hidden math rules are documented in the history of U.S. psychographics. We have moved from a society of pension-secure retirees to a society of market-anxious speculators. This shift has created a baseline level of cortisol in the American worker that spikes during a divorce. When Michael realizes that his 401k is being treated not just as a savings account, but as a universal balancing tool for every other government and private benefit in his life, the psychological result is often a withdrawal from the productive economy. We see people in their 50s quitting high-paying jobs or taking early retirement simply to stop the bleeding of their marital assets. This is a massive unquantified drag on the U.S. economy, driven entirely by the intersection of retirement law and marital dissolution. Furthermore, we must address the alimony recapture rule's impact on post-divorce mental health. Imagine it is 2028, 2 years after Michael's divorce was finalized. He has moved into a smaller apartment and is finally starting to feel a sense of peace. Then he receives a notice from the IRS. Because of the drop in his payments to Sarah, they are recapturing $40,000 of his previous deductions. Suddenly, he owes the government $15,000 in back taxes plus interest. This delayed fuse of financial trauma is a hallmark of the U.S. tax system. Prevents people from truly moving on. It keeps them tethered to the trauma of their divorce through an administrative umbilical cord that can last for years. The historical trend is clear. As our financial lives have become more individualized through 401ks, they have also become more legalized. Every dollar in that account is a potential point of litigation. Every historical contribution is a piece of evidence. In the next part, we are going to look at the loan trap. We will explore what happens when you have a 401k loan outstanding at the time of your divorce, and how that loan can be treated as a distribution that triggers immediate taxes and penalties for the spouse who didn't even take the money. We will also dive into the history of the qualified health coverage mandates and how they can be used to drain a 401k before the first QDRO is even signed. You need to see how the debt you think you owe yourself is actually a debt you owe the court. The mechanics of a 401k loan are often misunderstood as a simple transaction with oneself, but in the arena of a 2026 divorce, that loan transforms into a sophisticated legal trap. Imagine if Michael, 2 years prior to the filing, took out a $50,000 loan from his 401k to cover the costs of an emergency roof repair and some mounting medical bills for Sarah. In his mind, he was just moving money from his future self to his present self. He was paying himself back with interest, so he assumed there was no real loss. However, the moment the divorce papers are served, that loan becomes a pivot point for massive financial and psychological friction. Step by step, the court must now decide if that $50,000 liability is a marital debt or Michael's sole responsibility. If the funds were used for the roof of the marital home, it is likely marital. But if the records are messy, Sarah's legal team might argue that Michael used that money for personal expenses, or worse, to intentionally deplete the marital estate in anticipation of the split. This is where the documentation trap we discussed earlier becomes a nightmare. If Michael cannot prove where every cent of that $50,000 went, the court may credit the entire $950,000 balance to the marital pot while leaving the $50,000 debt solely on Michael's shoulders. The potential outcomes here are a mathematical disaster. If the court decides the account is worth $950,000 but Michael owes $50,000 back to it, he is essentially being asked to split a value that includes money he has already spent. This leads to a deemed distribution. If Michael cannot repay the loan in full before the QDRO is finalized, or if he loses his job during the litigation, the IRS views that unpaid balance as a premature withdrawal. This triggers immediate income tax and, because Michael is only 54, a 10% early withdrawal penalty. In 2026, the historical trend of using 401k loans as a primary emergency fund has created a massive wave of these accidental tax events, where divorcing Americans find themselves owing the IRS 5 figures for money they spent years ago. This brings us to a significant chapter in U.S. mental health history, the era of the debt-stress connection. During the late 1990s and early 2000s, as consumer debt exploded, clinical researchers began to identify a specific subset of anxiety disorders directly linked to revolving credit and retirement plan rating. The psychological weight of owing money to your own future is a unique form of cognitive dissonance. In Michael's case, every paycheck in 2026 has a loan repayment deducted from it. He is working 40 hours a week but only seeing the take-home pay of a 30-hour-a-week employee, all while trying to fund a separate apartment and pay legal retainers. This creates a state of chronic burnout that historical case studies link to a higher incidence of workplace errors and interpersonal conflict. Now, imagine if the court introduces a qualified medical child support order or a mandate for qualified health coverage. In the United States, health insurance has historically been tethered to employment, a legacy of the post-World War II labor market. When Michael and Sarah separate, Sarah may lose her coverage under Michael's employer-sponsored plan. In 2026, the cost of an individual silver-level health plan on the open market can exceed $800 a month. If Sarah has ongoing mental health needs, perhaps exacerbated by the trauma of the divorce, a judge may order Michael to use his 401k as collateral to ensure her COBRA premiums are paid during the pendant light period. This is a direct drain on the 401k before the first QDRO is even drafted. It is what we call the double depletion effect. The account is losing value to market fluctuations, it is being eaten by loan interest and potential penalties, and now it is being used as a checking account for insurance premiums. The historical trend in the U.S. has shifted toward viewing the 401k as the ultimate safety net for all life's failures, not just retirement. It has become the fund for medical crises, the fund for legal battles, and the fund for post-divorce survival. When we look at the history of U.S. mental health policy, specifically the Mental Health Parity and Addiction Equity Act of 2008, we see an attempt to make insurance cover more. However, the high deductibles of 2026 often mean that families still raid their 401ks to pay for the actual therapy sessions, creating a cycle where you are spending your future to survive the mental toll of the present. Let's look at a case study of the separation of service trap. Imagine if Michael, under the immense pressure of the divorce and the increased workload at his logistics firm, suffers a mental health breakdown and is forced to resign or is terminated. The moment he is no longer employed, his 401k loan usually becomes due in full, often within 60 to 90 days. If he cannot pay it, the deemed distribution happens instantly. This is the moment when the financial and mental health crises collide with total destructive force. He loses his income, his health insurance, and 10 to 15% of his retirement to taxes and penalties in a single fiscal quarter. Historical data from the 2008 and 2020 economic downturns shows that this specific sequence of events is a leading trigger for what sociologists call deaths of despair. The loss of the 401k is not just a loss of money, It is the loss of the finish line. For the American worker, the 401k is the only tangible evidence that the struggle will one day end. When that is taken away, the psychological infrastructure of the individual collapses. In 2026, we are seeing more courts attempt to intervene by freezing 401k loans during divorce proceedings. But these stay orders are often ignored by plan administrators who are governed by federal ERISA rules, not state family court orders. This conflict between state and federal law creates a no man's land, where the individual is crushed between two competing legal systems. To add more value to this masterclass, we have to look at the step-by-step strategy for managing a loan during a split. Step 1 is the immediate cessation of all new loans. Even if you need the money for a lawyer, a new loan during a divorce is often viewed as a violation of the automatic temporary restraining orders that go into effect in many states the moment a divorce is filed. Step 2 is the formal appraisal of the loan's purpose. If Michael can show the money went to the house, he can negotiate for Sarah to take a larger portion of the house's equity in exchange for him keeping the 401k debt. Step 3 is the synchronization of the QDRO with the loan balance. A well-drafted QDRO must explicitly state whether Sarah is receiving 50% of the gross balance or 50% of the net balance after the loan is deducted. A mistake here can cost Michael another $25,000. The mental health history of the U.S. shows that we have consistently underestimated the impact of administrative complexity on human well-being. We have built a retirement system that requires the precision of an accountant and the nerves of a day trader, and then we subject that system to the most emotional event in a person's life. The 401k loan is the perfect symbol of this failure. It is a tool of convenience that becomes a weapon of mass financial destruction the moment the domestic contract is broken. But there is an even more subtle danger lurking in the paperwork. It is something that even seasoned divorce attorneys often overlook until it is too late. It involves the way the 401k interacts with the future, specifically the way the U.S. government becomes a silent, preferred beneficiary of your retirement account through something called the Inherited IRA Trap and the Secure Act 2.0 regulations. As Michael tries to settle his 401k debt, he is unwittingly setting a trap for his children that will not spring for another 20 years. In the next part, we are going to dive into the ghost of the Secure Act. We will see how the 2026 implementation of these tax laws means that even if Michael wins his 401k battle today, he might be losing the war for his family's legacy. We are going to look at the 10-year rule, and why splitting a 401k in a divorce today creates a massive tax ticking time bomb for the next generation. The complexity is about to shift from your present to your children's future. The Setting Every Community Up for Retirement Enhancement Act, or the Secure Act of 2019, followed by its successor Secure 2.0 in 2022, fundamentally rewrote the inheritance laws for 401ks in the United States. For Michael, who is currently watching half of his retirement assets transfer to Sarah, the long-term implications are often invisible until he considers his children, David and Emily. Before these legislative shifts, the historical trend was the stretch IRA. If Michael had passed away and left his 401k to his children, they could have stretched the required minimum distributions over their own lifetimes. This allowed the money to remain in a tax-advantaged environment for decades, potentially turning a modest inheritance into a multi-generational legacy. But as of 2026, the rules of the game have been permanently altered. The Secure Act introduced the 10-year rule for most non-spouse beneficiaries. This means that if David and Emily inherit what is left of Michael's 401k, they must withdraw the entire balance within 10 years of his death. There is no more stretching. There is no more multi-generational tax shelter. For a family already reeling from the financial fragmentation of a divorce, this creates a concentrated tax burden that can effectively strip away another 30 to 40% of the remaining wealth. Imagine if David is in his peak earning years when he inherits Michael's split 401k. Because the account was already halved by the divorce, the total amount is smaller, but the IRS requirements are more aggressive. David is forced to take large distributions on top of his high salary, potentially pushing him into the highest federal tax bracket. This is the 10-year tax ticking time bomb. The historical case studies of the 1990s showed that middle-class wealth was largely built on the ability to defer taxes. By 2026, that ability has been severely curtailed for the children of divorced households. They are inheriting smaller pieces of the pie, and are forced to consume those pieces in a way that maximizes the government's take. The mental health history of this shift is deeply tied to what psychologists call generational wealth anxiety. In the mid-20th century, the American dream was built on the idea of leaving the world better for your children. This was a stabilizing psychological force for the American worker. However, the intersection of high divorce rates and the Secure Act has created a new paradigm where the aging worker feels like a failure for not being able to protect their children's financial future. Michael is not just depressed because he lost half his money to Sarah. He is experiencing a profound sense of existential dread because he realizes the structural advantages he hoped to pass down have been legislated out of existence. Research into U.S. mental health trends in the 2020s shows that the sandwich generation, those caring for aging parents while supporting their own children, is experiencing burnout at rates 40% higher than previous generations. This burnout is not just physical, it is financial. When a 401k is split in a divorce, the parents often have fewer resources to fund their own long-term care. This means David and Emily will likely have to step in financially for Michael later in life. This creates a cycle of stress where the children are paying for the parents' lack of retirement funds, while simultaneously being taxed more heavily on whatever inheritance does remain. Let us look at the step-by-step breakdown of how the 2026 IRS regulations on RMDs apply to these inherited accounts. Step 1 is identifying the status of the beneficiary. Unless the child is disabled or chronically ill, they almost certainly fall under the 10-year rule. Step 2 is the annual distribution requirement. Under the final regulations issued by the IRS for 2026, if the original owner, Michael, had already reached his required beginning date for distributions, the children cannot simply wait until year 10 to take the money. They must take annual distributions in years 1 through 9, based on their own life expectancy, and then empty the account in year 10. This removes the flexibility to wait for a low-income year to take the tax hit. Step 3 is the state tax complication. In states with high income taxes, such as California or New York, these forced distributions can lead to a combined effective tax rate exceeding 50% in some scenarios. This is why we call it the ghost of the Secure Act. It haunts the retirement account long after the divorce is finalized. The psychological impact on Michael is a sense of powerlessness. He feels that the state and the federal government are silent partners in his marriage and his death, taking a cut of every transition. The historical trend of U.S. retirement policy since the 1970s has been a steady movement away from collective security toward individual risk, but with increasing government oversight of the exit. We moved from pensions to 401ks, which shifted the investment risk to Michael. Then we moved to the Secure Act, which shifted the tax risk to his children. In 2026, the complexity of managing these overlapping risks while going through a divorce is enough to trigger clinical levels of cognitive overload. Case studies of divorce mediation in the current year show that many couples are now including legacy tax planning in their settlements, recognizing that a 50-50 split of a 401k today does not mean an equal outcome for their heirs tomorrow. Consider the case of a character named Emily, Michael's daughter. She is a freelance graphic designer with a fluctuating income. In a pre-Secure Act world, she could have taken minimal distributions from an inherited 401k during her lean years and left the rest to grow. In the 2026 reality, she is forced to take money even when she doesn't need it, potentially losing her eligibility for certain tax credits or subsidies that are based on adjusted gross income. This is the collateral damage of the 401k divorce. The financial instability of the parents' divorce ripples through the children's tax returns for a decade. The history of mental health in the U.S. suggests that during times of high economic complexity and low social support, individuals look for scapegoats. In the context of a 401k divorce, this often manifests as lifelong resentment toward the ex-spouse. Michael might blame Sarah for the fact that David and Emily are facing these tax burdens, ignoring the fact that it was federal legislation that created the trap. This resentment further degrades the mental health of the entire family unit, leading to what family therapists call the fractured legacy. Furthermore, we must address the 2026 implementation of the Secure 2.0 provisions regarding catch-up contributions. If Michael tries to aggressively rebuild his 401k after the divorce, he discovers that as of 2026, catch-up contributions for high earners must be made into a Roth account, not a traditional pre-tax account. This means he loses the immediate tax break he desperately needs to offset his legal fees. Every attempt to recover from the divorce is met with a new regulatory hurdle. This is not a coincidence. It is the historical result of a tax system that is increasingly hungry for immediate revenue as the U.S. population ages. As we go deeper into this masterclass, the picture becomes even more complex. We have covered the split, the loans, and the legacy. But there is a technical error that happens in nearly 30% of all 401k divorces. An error so catastrophic that it can lead to the total loss of the account to the IRS before a single dollar reaches either spouse. It involves the interaction between the QDRO and the plan's specific vesting schedule. In the next part, we are going to expose the vesting trap in the ERISA clawback. You will see how an employee who isn't fully vested can accidentally lose their entire retirement during a divorce, and how the company you work for might have the legal right to take back the money you thought was yours. We are going to look at the historical cases of corporate bankruptcy, and how they can turn a 401k divorce into a zero-sum game where no one wins except the creditors. The legal architecture is about to get much more aggressive. The vesting trap is perhaps the most insidious administrative oversight in the history of U.S. retirement law, and in 2026, it remains the primary reason why 50-50 splits are almost never actually equal. To understand this, we have to look at Michael's logistics firm and the specific architecture of his 401k plan. While Michael has been in the industry for nearly 3 decades, his current firm was the result of a massive corporate merger in 2024. As part of that merger, the new entity established a graded vesting schedule for all employer matching contributions. Michael's statement shows a total balance of $950,000, but tucked away in the fine print is a distinction between the total account balance and the vested account balance. Imagine if Michael's attorney drafts a QDRO that simply states Sarah is entitled to 50% of the account balance as of the date of divorce. On the surface, this seems fair. However, if $100,000 of that total balance consists of recent employer matches that are only 60% vested, Michael only actually owns $60,000 of those dollars. The other $40,000 is what we call ghost money. It is on the statement, but it hasn't legally been earned yet. If the plan administrator executes the QDRO and sends Sarah $475,000, they are taking that money from the vested portion of the account. Michael is left with the remaining vested funds and the unvested ghost money. If Michael were to leave the firm or be laid off before those funds fully vest, that $40,000 vanishes, returning to the employer. Michael hasn't walked away with half. He has walked away with significantly less, while Sarah received her portion in hard, vested cash. Historical trends in ERISA litigation show that these vesting errors are a byproduct of the shift from defined benefit plans to defined contribution plans. In the old pension system, vesting was a binary, you either had a pension or you didn't. In the 401k era, vesting is a sliding scale of ownership that changes every single pay period. Step by step, a proper 401k audit during a divorce must include 3 specific actions. Step 1 is the request for a summary plan description, which outlines the exact vesting schedule, whether it is a cliff vesting schedule, where you own nothing until year 3, or a graded schedule, where you gain 20% ownership each year. Step 2 is the calculation of the separate property interest in the unvested portions. Step 3 is the inclusion of language in the QDRO that specifically addresses what happens to unvested shares if they fail to vest post-divorce. The mental health implications of this rug pull are profound. In the history of U.S. industrial psychology, the concept of the social contract was built on the idea that if you put in the time, you get the reward. The vesting schedule is the modern legalized way of dangling that reward just out of reach. When a worker like Michael realizes that he is essentially subsidizing his ex-spouse's retirement with money he hasn't even fully earned yet, it creates a state of vocational resentment. This resentment often leads to a decrease in productivity and a sense of betrayal by the employer. Historical case studies from the early 2010s tech bubble show that when employees lose unvested options or matches during a life crisis, their rate of professional burnout triples within 18 months. In 2026, with the added pressure of a hyper-competitive logistics market, Michael's mental health is being eroded by the very structure of his compensation package. This leads us to the ERISA clawback, a legal mechanism that feels like something out of a dystopian novel. Under federal law, plan administrators have a fiduciary duty to the plan as a whole. This means if they make a mistake, such as overpaying a former spouse because they failed to account for a vesting schedule or a previous loan, they are legally obligated to recover that money. This is the clawback. Imagine if, 2 years after the divorce is finalized, Michael's firm performs a routine internal audit. They realize they overpaid Sarah by $20,000. They don't just ask Sarah for the money back. They can actually place a lien on Michael's remaining 401k balance, or even garnish his future employer contributions to make the plan whole. The psychological toll of a clawback is what we call administrative trauma. It is the realization that a legal finality, like a divorce decree, is never truly final in the eyes of federal retirement law. In 2026, we are seeing a spike in these cases as AI-driven auditing software becomes standard for large plan administrators. What used to be a human error that went unnoticed for decades is now being caught in milliseconds by an algorithm. This creates a state of permanent financial insecurity. The historical trend of the American middle class was toward stability through homeownership and retirement. But when your retirement account can be raided years later to fix an administrator's math error, the very idea of stability becomes a myth. Now let's look at the worst-case scenario: corporate bankruptcy. While the 401k is generally protected from the creditors of the employer under ERISA, there are exceptions that most people ignore. Specifically, if Michael had a non-qualified deferred compensation plan, often called a top hat plan, those funds are considered general assets of the employer. In a divorce, if Michael agrees to give Sarah more of the liquid 401k in exchange for keeping his top hat plan, he is taking on massive risk. Imagine if in 2027, Michael's logistics firm goes under. The 401k is safe, but the top hat plan is wiped out by the firm's creditors. Sarah has her money and Michael has zero. The history of corporate failures like Enron and WorldCom taught us that retirement security is often tied to the health of the institution. However, the mental health history of the US shows that we have a cognitive bias toward believing our own employer is too big to fail. We saw this in the 2008 crisis and the 2023 banking collapses. In 2026, the complexity of global trade means that even a logistics giant is vulnerable. When Michael negotiates his 401k split, he is not just negotiating with Sarah. He is negotiating with the future solvency of a corporation he does not control. This creates a state of hypervigilance that historical data links to chronic insomnia and anxiety-related physical ailments. To navigate this, we must examine the step-by-step process of protecting a 401k from corporate volatility during a divorce. Step 1 is the segregation of assets. As soon as the QDRO is approved, the funds should be moved into a separate account in the ex-spouse's name to insulate them from any issues with the original participant's employment status. Step 2 is the valuation of non-qualified plans with a risk-adjusted discount. You cannot value a top hat plan at dollar for dollar if the company is in a volatile sector. Step 3 is the inclusion of an indemnity clause in the divorce decree, stating that if a clawback occurs due to an administrator's error, the party who received the overpayment is responsible for the repayment. The potential outcomes for Michael in 2026 are highly dependent on his ability to see through the total balance illusion. If he fails to account for vesting, clawbacks, and corporate risk, he is essentially walking into a financial ambush. The mental health history of the US shows that we have consistently moved toward a user-pays system for everything, including the management of our own retirement risks. The 401k is a powerful tool, but in the context of a divorce, it is a liability that requires constant monitoring. But there is a layer even deeper than corporate risk. It is the hidden impact of the 401k split on your future ability to access credit and housing. Most people don't realize that the cleanness of your 401k split directly dictates your mortgage eligibility and your interest rates for the next decade. As Michael prepares to move out of the marital home, he is about to find out that the QDRO he just signed has a secondary effect on his credit score that no one warned him about. In the next part, we are going to dive into the credit score collision. We will see how a 401k distribution can accidentally trigger a debt-to-income ratio crisis, and we will examine the history of the mortgage recast trap for divorcing seniors. We are going to look at the secret ways banks use your retirement statements to judge your character in a post-divorce world. The math is moving from your retirement account into your current living room. As Michael stands in the lobby of a glass-towered bank in Smyrna, Georgia, in the spring of 2026, he is carrying a folder that contains the summary of his life's work. He is there to apply for a mortgage on a modest 2-bedroom condo, a necessary step to finally move out of the temporary rental he has inhabited since the divorce began. He has $475,000 left in his 401k, a steady job, and a signed divorce decree. In his mind, he is a prime candidate for a loan. But as the loan officer scrolls through Michael's trended credit data, a silent alarm begins to ring within the bank's automated underwriting system. This is the credit score collision, and it is the moment where the private trauma of Michael's divorce becomes a public disqualifier. To understand why this happens, we must look at the historical evolution of credit in the United States. Before 1989, credit was largely a matter of local reputation and personal relationships with branch managers. But with the introduction of the FICO score in 1989, The American character was distilled into a 3-digit number. This shift coincided exactly with the peak of the U.S. divorce rate and the maturation of the 401k system. By 2026, lenders have moved beyond the simple FICO score to something called FICO 10T, which analyzes trended data over a 24-month period. For Michael, this is catastrophic. The last 24 months of his life have been defined by the financial volatility of his split. Even if he has never missed a payment, the sudden closure of joint accounts, the spike in credit card utilization to pay legal retainers, and the halving of his liquid assets look like a downward spiral to an algorithm. Imagine if Michael's loan officer explains that his debt-to-income ratio, or DTI, is now mathematically unsustainable. When he was married, the household had 2 incomes and 1 mortgage. Now Michael has 1 income, but the bank still sees the joint debt of the marital home as his responsibility because his name has not yet been removed from the original deed. In the eyes of the lender, Michael is carrying the debt of 2 households on the back of a single, fragmented retirement account. This is a common historical trend where the legal speed of a divorce outpaces the administrative speed of credit reporting. The mental health implications of this collision are documented in the history of the quantified self movement. When a human being is told that their moral character and financial stability are represented by a number they cannot control, it triggers a state of financial dysphoria. In the mid-2000s, U.S. psychologists began to see a surge in patients who felt that their credit score was a more accurate reflection of their worth than their actual achievements. In 2026, for a man like Michael, the rejection of his mortgage application is not just a logistical hurdle. It is a psychological confirmation that he has failed the modern American test of adulthood. The historical shift toward individual responsibility for retirement has meant that if your 401k is split and your credit is damaged, you are viewed as a high-risk entity by the very institutions that profited from your decades of contributions. This brings us to the mortgage recast trap, a technical maneuver that many divorcing seniors use in an attempt to save their cash flow, often with disastrous results. Imagine if Michael decides to use $100,000 of his remaining 401k to pay down a significant portion of the principal on his new condo to keep the monthly payments low. In a standard mortgage environment, simply paying down the principal does not change the monthly payment. It only shortens the life of the loan. To lower the payment, Michael must request a recast. Step by step, the recast process is a bureaucratic gauntlet. Step 1 is the payment of a large lump sum toward the principal. Step 2 is the formal request to the servicer to re-amortize the remaining balance over the original term. Step 3 is the payment of a processing fee, which in 2026 can range from $250 to $500. But here is the trap. During the weeks it takes to process the recast, the bank may still report the original, higher payment as Michael's obligation. If his DTI is already tight, this administrative lag can cause other lines of credit to be frozen or interest rates on his car loan to spike. Historical case studies from the post-2008 era show that many individuals burned through their remaining retirement liquidity to lower their debt, only to find that their monthly obligations remained identical, leading to a total cash flow collapse. We must also examine the historical trend of alternative credit data, or ACD. By 2026, banks are not just looking at your FICO score. They are looking at how much you pay in legal fees, your utility payment history, and even your digital footprint. If Michael's bank sees repeated payments to a high-profile family law firm, they categorize him as being in a state of litigation risk. This is the secret way banks judge your character. In the 1920s, they judged you by your handshake and your family name. In 2026, they judge you by the stability of your legal environment. A 401k divorce is a loud, digital signal to the banking system that your life is in flux. The potential outcomes for Michael are a series of cascading rejections. He cannot get the condo, so he remains in the rental. The rental costs 30% more than the mortgage would have, further depleting his ability to rebuild his 401k. This is the scarcity trap. The history of U.S. mental health policy has often failed to account for this environmental stressor. We treat anxiety with medication, but we do not treat the underlying structural reality that Michael is being penalized by a banking system that views his divorce as a voluntary reduction in creditworthiness. To add more value to this masterclass, we have to look at the step-by-step credit protection strategy. Step 1 is the immediate freezing of all joint credit lines the moment the separation is official. You cannot wait for the final decree. Step 2 is the creation of a credit bridge. This involves taking out a small secured loan against your own 401k, If the plan allows, to establish a new individual history of on-time payments before you apply for a major mortgage. Step 3 is the manual override request. In 2026, most credit decisions are automated, but a skilled attorney can sometimes force a manual review by a human underwriter who can account for the QDRO as a one-time event rather than a trend of instability. The psychological toll of this constant surveillance is what we call credit anxiety disorder. It is the fear of checking one's phone and seeing a notification that a credit limit has been lowered because of a perceived change in risk. The history of American individualism has brought us to a point where our retirement security and our current housing security are tethered to the same volatile set of data points. Michael is realizing that while he fought for his half of the 401k, he forgot to fight for the reputation of his social security number. As we look at the historical progression of these financial systems, we see a move toward total integration. Your 401k, your credit score, your health records, and your marital status are becoming a single interconnected web of risk assessment. But there is a final, even more terrifying layer to this story. It is the moment when you realize that even if you survive the credit collision and keep your half of the retirement, you may still lose everything to a system you didn't even know you were part of. It involves the way the US government handles long-term care and the brutal reality of the Medicaid spend down. In the next part, we are going to dive into the Medicaid spend down trap. We will see how a 401k divorce in your 50s can disqualify you from government-assisted care in your 80s, and we will examine the historical case of the 5-year look-back that turns your 401k split into a fraudulent transfer in the eyes of the state. We are going to look at the secret math of nursing home poverty and why your divorce settlement might be the reason you end up in a state-run facility with no assets left. The math is moving from your living room to the hospital bed. The math of nursing home poverty is a cold, algorithmic reality that most Americans in 2026 are completely unprepared to face, especially those whose retirement accounts have been fragmented by a divorce. To understand the Medicaid spend-down trap, we have to look at the intersection of Michael's current 401k balance and the projected costs of long-term care in the mid-2020s. In 2026, the national average cost for a private room in a skilled nursing facility has climbed toward $15,000 per month in many metropolitan areas. For Michael, who is now left with $475,000 after his split with Sarah, this is a terrifying calculation. His entire remaining life savings represents roughly 31 months of professional care. If Michael lives into his 80s and requires long-term assistance, his 401k will not be a legacy. It will be a temporary bridge to total indigence. In the United States, Medicaid is the primary payer for long-term care, but it is a means-tested program designed only for those with almost no assets. To qualify, in many states, an individual can have no more than $2,000 in countable resources. A 401k is considered a countable resource. This is where the historical trend of the Medicaid look-back rule becomes a legal minefield. Under federal law, state Medicaid agencies conduct a 60-month or 5-year audit of all financial transactions prior to an application for benefits. They are looking for any transfer of assets for less than fair market value. Imagine if Michael, during his 2026 divorce, decided to be generous. Perhaps he felt guilty about the breakdown of the marriage, or he wanted to ensure Sarah was extra secure, so he agreed to give her 60% of the 401k instead of 50%. To Michael, this was a moral decision. To a Medicaid caseworker 15 years from now, this could be viewed as a disqualifying transfer. If the state determines that the extra 10% was a gift rather than a legally mandated equitable distribution, they can impose a penalty period, a duration of time during which Michael is ineligible for Medicaid coverage, despite having no money left to pay for his care. This historical shift in policy, which intensified with the Deficit Reduction Act of 2005, turned the divorce decree into a document that the state can relitigate decades after the fact. The mental health history of aging in America is a narrative of increasing isolation and the fear of the poor farm. In the late 19th and early 20th centuries, the lack of a social safety net meant that the elderly poor were often sent to almshouses or county farms, institutions defined by stigma and substandard care. The 1965 Social Security Amendments, which created Medicaid, were supposed to end this era. However, the psychological legacy of the poor farm remains in the American psyche as a deep-seated fear of losing one's autonomy. In 2026, this fear has evolved into what clinicians call elderly poverty anxiety. For Michael, The realization that his 401k divorce has placed him on a direct path toward a state-run facility is a source of chronic, low-grade trauma. Historical trends in U.S. psychographics show that individuals who perceive themselves as downwardly mobile in their senior years suffer from significantly higher rates of geriatric depression and cognitive decline. When a 401k is halved, the margin for error in an individual's life disappears. Michael can no longer afford the specialized memory care or the high-end assisted living facilities that his original $950,000 balance might have supported. He is now tethered to the Medicaid system, a system that, by design, requires him to be broke to be helped. Let us look at the step-by-step reality of the spend down. Step 1 is the exhaustion of all private insurance and personal savings. Michael must pay the $15,000 a month out of his 401k until the balance hits that $2,000 threshold. Step 2 is the income cap test. In many Miller Trust or qualified income trust states, if Michael's monthly income from Social Security and whatever remains of his 401k distributions exceeds a certain limit, he is technically ineligible for Medicaid, unless he funnels that excess income into a specific legal trust. Step 3 is the estate recovery program. Even after Michael passes away, the state can sue his estate, meaning his children David and Emily, to claw back the costs of the care they provided. The 401k divorce of 2026 effectively ensures that there is nothing left for the next generation to inherit. This brings us to the community spouse protection rules, which highlight the brutal nature of the post-divorce landscape. If Michael and Sarah had stayed married and Michael needed nursing home care, the law would allow Sarah to keep a significant portion of their assets, known as the Community Spouse Protected Resource Allowance, so that she would not be left destitute. In 2026, this allowance can be as high as $150,000. But because they are divorced, Sarah is no longer a community spouse. She is a legal stranger. The protections that the U.S. government built to prevent the impoverishment of the healthy spouse do not apply. Both Michael and Sarah are now individual units, each vulnerable to the total depletion of their respective 401k halves. The historical case studies of the Medicaid divorce from the 1980s and 90s provide a dark contrast to Michael's situation. In those years, some couples actually filed for divorce specifically to protect assets from nursing home costs, a desperate strategy that led to stricter anti-impoverishment laws. Today, Michael is going through a real divorce, but he is suffering the same potential outcomes as those who tried to game the system. He is losing the economy of scale that a shared household provides. The cost of one room in a nursing home is nearly the same as the cost of two, but Michael only has half the resources to pay for it. The psychological toll of this longevity risk is a primary driver of mental health crises in the American 50-plus demographic. We are the first generation in human history expected to fund a 30-year retirement through a volatile market-based account. When that account is fractured by divorce, the potential outcomes shift from comfortable retirement to survival mode. Historical data from the mid-2010s suggests that the fear of outliving one's money is now more prevalent than the fear of death itself. In 2026, for a character like Michael, this isn't just a fear. It is a mathematical certainty that he must manage every day. To add more value to this masterclass, we must examine the Qualified Longevity Annuity Contract, or QLAC. In 2026, the IRS allows individuals to move a portion of their 401k into a QLAC, which defers distributions until age 85. This is often marketed as a way to insure against outliving your money. But in a divorce, the QLAC is an illiquid asset that is incredibly difficult to split. If Michael's 401k is tied up in a QLAC, Sarah's attorney may demand a larger share of the liquid cash to compensate, leaving Michael with a future promise of money that he may not live long enough to collect, while he starves in the present. The history of U.S. mental health is a history of the unsupported individual. We have dismantled the institutions, we have individualized the retirement, and we have legalized the dissolution of the family. The 401k divorce is the final stage of this process. It leaves the individual standing alone before the most expensive period of their life, with a bank account that has been surgically reduced by the legal system. Michael's journey through the 2026 divorce court is not just about who gets the dog or the house. It is a high-stakes negotiation for who gets to avoid the poor farm of the 21st century. But even in this grim landscape, there is a path toward what we call the final reconstruction. There are specific historically proven ways to rebuild a 401k after a split, utilizing the very laws that seem to be working against you. The system that broke your retirement also contains the blueprints for its restoration, if you know where to look in the tax code of 2026. In the final part of this masterclass, we are going to reveal the Phoenix strategy. We will look at the catch-up acceleration rules, the Roth conversion ladder, for the divorced professional, and the historical trend of solo 401ks, for the newly single entrepreneur. We are going to show you how Michael can take his $475,000 and, through a series of specific steps, turn it back into a seven-figure legacy. The deep dive concludes with the ultimate guide to post-divorce financial and mental recovery. The math of the end is about to become the math of a new beginning. The math of a new beginning starts with a radical reassessment of what we call the recovery period. For Michael, standing in the wreckage of his financial life in 2026, the natural instinct is to mourn the lost $475,000. However, the Phoenix strategy requires a pivot from the sunk cost fallacy to the concept of post-traumatic growth. Historically, the American worker has shown an incredible capacity for financial recalibration following systemic shocks. We saw this after the stagflation of the 1970s and the housing collapse of 2008. In 2026, the tool for this recalibration is the Roth conversion ladder, a technical maneuver that leverages the lower tax bracket often occupied by a newly single person. Imagine if Michael, now filing as a single taxpayer, finds himself in a lower marginal tax bracket than he was when he filed jointly with Sarah. This creates a window of opportunity. Step by step, Michael can begin converting portions of his remaining traditional 401k into a Roth IRA. Step 1 is the calculation of the tax gap. If Michael's income is now $70,000 instead of the household's former $200,000, he has significant room in the lower tax brackets to absorb additional income from a conversion. Step 2 is the systematic transfer. By moving $50,000 a year into a Roth account, he pays the taxes now at his lower rate, and from that point forward, every cent of growth and every future distribution is tax-free. Historical trends suggest that for those who undergo a late career divorce, the Roth conversion is the most effective way to protect their remaining assets from the inevitable tax hikes of the 2030s. This leads us to the 2026 implementation of the Secure 2.0 Super Catch-up provisions. Historically, catch-up contributions were a flat amount for anyone over 50. But as of 2026, the law allows for a special increased limit for workers aged 60 to 63. Michael is 54, which means he has a 6-year runway to prepare for this surge. The potential outcomes are significant. If Michael can maximize his standard 401k contributions and then hit the super catch-up phase with an additional $10,000 or more per year, he is utilizing the back end of his career to compensate for the mid-career split. This is the math of the final sprint. The mental health history of this recovery phase is rooted in the shift from external validation to internal autonomy. In the 1950s and 60s, a man's identity was his company and his family. When one failed, the other usually followed. But in the 2020s, the concept of the portfolio career has emerged. Michael doesn't just have to be a logistics director. He can be a logistics consultant. This brings us to the solo 401k. Imagine if Michael takes his decades of experience and starts a side hustle consultancy. Under the 2026 tax code, a solo 401k allows him to contribute as both the employer and the employee. The total contribution limit can exceed $60,000 a year. This is how the Phoenix truly rises. He is no longer limited by the matching caps of a single firm. He is using his own intellectual property to turbocharge his retirement. The psychological component of this strategy is what clinicians call the locus of control. In the history of U.S. mental health, the 1980s saw the rise of cognitive behavioral therapy, CBT, which focused on changing thought patterns to change outcomes. For Michael, this means moving from, "I lost half my 401k," to, "I have optimized the half I kept." Research shows that individuals who actively engage in financial rescripting post-divorce have a 40% lower rate of chronic stress disorders than those who remain in a state of financial mourning. In 2026, the recovery is as much about the brain as it is about the brokerage account. Let's look at a case study of a character named Robert, who went through a similar 401k divorce in 2022. Robert used the Rule of 55. This is a historical provision in the IRS code that many people overlook. If you leave your job in or after the year you turn 55, you can take penalty-free distributions from your current 401k. Robert used this to bridge the gap between his divorce and his second career without touching his principal growth assets. By 2026, Robert's split account had recovered 80% of its original value through aggressive catch-ups and a pivot to a high-growth AI sector logistics firm. The potential outcome was not just financial parity, but a renewed sense of professional purpose. However, the final step of the masterclass involves the diversification of meaning. Historically, Americans have tied their entire self-worth to their 401k balance. This is a fragile way to live. The mental health history of the US is littered with the stories of people who had the money but lost the why. Michael's recovery must include a social capital investment. He needs to rebuild the community that was lost in the divorce. In 2026, we see the rise of financial co-housing and retirement cooperatives, where divorced or single seniors pool resources to achieve the same economy of scale they once had in marriage. This is the ultimate workaround for the Medicaid spend-down trap we discussed. By sharing costs, Michael preserves his 401k for longer, delaying the need for state-run care. Step by step, the final reconstruction looks like this. Step 1. Audit the QDRO for vesting and clawback errors. Step 2. Execute a Roth conversion strategy to maximize the new lower tax bracket. Step 3. Utilize the Secure 2.0 Super Catch-up rules as soon as eligibility begins. Step 4. Pivot to a solo 401k if any side income is generated. Step 5, and most importantly, reestablish a support network that reduces the longevity risk of being a single retiree in America. The history of the 401k is a history of accidental complexity. It was never intended to be the sole pillar of the American retirement system, yet here we are. It was never intended to be the most litigated asset in a divorce, yet it is. But as we have seen through these 10 parts, the complexity is also a source of leverage. If you understand the vesting, the loans, the Social Security offsets, and the tax recaptures, you are no longer a victim of the system. You are a navigator of it. Michael in 2026 is not the same Michael from the start of this video. He is informed, he is strategic, and he is psychologically resilient. As we conclude this deep dive masterclass, it is clear that the 401k divorce is the defining financial challenge of our era. It is where the laws of the state, the rules of the IRS, and the history of our own mental health collide. We have covered the trauma, the traps, and the tactics. But the conversation does not end here. The landscape of the American economy is shifting again, and the very definition of a retirement account is about to undergo its most radical transformation since 1978. What happens when the 401k is no longer tied to an employer at all? What if the next phase of US history involves a universal portable account that follows you from job to job and marriage to marriage without the need for a QDRO? And how will the rise of decentralized finance and AI-driven estate planning change the way we view marital property in the next decade? The math of the future is already being written in the halls of Congress and the laboratories of Silicon Valley. In our next series, we are going to dive into the death of the traditional estate and the rise of the digital legacy. You won't want to miss how the next generation of wealth is being hidden in plain sight.